Welcome to our industry-specific podcast series number 4. My name is Kate Bay.
And my name is Henry. And in today's podcast, we will examine IPR protection in China for the OEM industry.
Great! Henry, could you explain to us what OEM means?
Yes, sure. The term OEM, which stands for Original Equipment Manufacturer, designates a company that only makes a part of a product or a subsystem to be used in another company's end product. By extension, OEM also designates the agreement whereby one company commissions another to manufacture products according to certain specifications and to affix a trademark on such products. The said products are delivered to the commissioner who sells them in the market under his own name.
I see. And why is the OEM industry relevant in China?
Well, China is the world's leading manufacturer, attracting manufacturing contracts from global customers in almost every industry by capitalizing on Chinese OEM's core strength, meaning low labor costs, experienced manufacturers, and skilled workers. European SMEs in recent years indicate that OEM is still a popular format, in particular for those adept at design and invention but lacking the means to launch a full-scale investment in China.
Very interesting. For better understanding, can you give me an example of an OEM?
Of course. An example of this would be component parts, like a computer's processor, including items that go into the assembly of the final product. A famous Dutch OEM company would be Philips.
Right. Then tell me, what kind of precautions need to be taken when relating IPR to the OEM industry?
Well, precautions need to be taken in the drafting of the OEM contract to ensure quality and timing of the production and delivery. Supplemental provisions which protect the intellectual property rights related to the goods are also a crucial element of a successful China OEM strategy.
Then what are frequent IP issues in China's OEM industry?
Products to be manufactured by OEM in China are usually covered by one or several types of IP rights, such as trademarks, copyright, designs, or technical know-how. Therefore, it is very important for SMEs to remember when authorizing a third party to manufacture products, the IP owner should carefully examine the status and level of protection of its IP rights in the country of production.
I have a question for you. When I've already filed my company's trademark in my home country here in Europe, do I have to register my trademark in China as well?
Okay, that's an excellent question. Trademarks are protected on a country-by-country basis, and China follows a first-to-file system that grants trademarks to the first individual or company to register it. This means that a foreign trademark is not automatically protected in China. Before considering OEM production in China, and certainly before the beginning of the OEM process, SMEs should file all trademarks in with Chinese authorities, either directly in China or through international processes. And it's important for SMEs to remember that once the trademark is registered, SMEs can authorize the OEM factory in safety. But if the trademark is not registered before the process begins, then SMEs open themselves to IP piracy.
Wow, good to know. So what are the things that a company can enforce with a valid trademark registration?
Well, with a valid trademark registration, you can grant a license to the OEM factory. There are two types of licenses, exclusive and normal. Generally, a non-exclusive license is slightly safer in that it allows more freedom for terminating a contract and switching to a different factory. On the other hand, the OEM will have more power and more incentive to act against possible counterfeiters if it has an exclusive license.
So then what happens when a country fails to file a trademark?
Oh, failing to file a trademark before embarking on OEM is courting disaster, because the trademark may be registered by another person or company who can then sue you, stop your products at the border, or claim compensation for infringing their mark that has already been granted in China. This is what they call trademark hijacking.
Oh, that sounds awful. You've mentioned design patents before. What are they?
Products manufactured by OEM factories are usually made in accordance with specific drawings, blueprints provided by the foreign company. It is advisable to file in advance for the registration of what China calls design patents in order to protect these industrial designs. But be aware that Chinese law requires that design patents be novel, meaning that the design must not have been disclosed anywhere in the world before the filing of the application. If an SME applies for a registration for a design which is not novel, the design will still be granted, as a design patent is not subject to examination by the State Intellectual Property Office, the SIPO. However, the patent will be subject to invalidation.
Great. What about copyright in China?
Chinese law protects copyright without any need for registration. Although copyright is automatically granted, registration is possible and highly recommended to facilitate the submission of evidence of ownership of the copyright in case of dispute or enforcement action. I would like to emphasize that copyright should be registered as early as possible, as the courts tend to disregard registrations if they have been made after proceedings have begun.
Great. Now tell me, then how can one prove the ownership of the copyright?
A company can do so by preserving original copies of all documents establishing the creation of the work, such as sketches, drafts, various prior iterations of the work, as well as the contractual documents showing the chain of ownership over the rights.
Very informative. Thanks, Henry. I was not aware of this before.
Yes, it's quite problematic that not all companies are aware of the importance of IP in general.
So, when a company wants to engage in an OEM contract, what are some questions that should be raised and discussed between the commissioner and the OEM factory beforehand?
Some question that should be raised, who owned the prototype produced by the OEM factory based on the design provided by the commissioner? Who is responsible for final products infringing a third party's IP, such as trademark, design, and handling of certain contingencies. For example, if the factory does not destroy returned or flawed products and instead they circulate them in the market. SMEs should require the candidate OEM factories to sign a NDA, a non-disclosure agreement, to maintain the secrecy of its business plans, IP information disclosed in conversations or emails, etc. It's important to know that NDAs, however, are not foolproof and may fail to prevent information leaks or trademark squatting. Registering IP before entering negotiations, let alone entering China, will be key to avoid these issues in terms of trademark and design protection. It's recommended to ensure the appropriate protection of trade secrets and know-hows via contractual and other means. So elaborate contracts with good IP clauses are incredibly important.
Excellent. Could you elaborate a bit more? Which points should be considered carefully in order to mitigate IP risks in OEM contracts?
Well, firstly, definition of the commissioned product should be specified, because if the product commissioned is not properly defined and described in a contract, it will be very difficult to prove the non-compliance of the product and thus to terminate contracts or claim compensation. Other points to consider would be the case of overproduction and defective products, IP use and confidentiality, IP flow guarantees, IP enforcement, termination of the contract, using arbitration versus domestic courts, and the language of the contract.
Well, it seems advantageous for European SMEs to draft their contract in English.
Ooh, no. Although it may seem counterintuitive, but drafting contracts in Chinese can greatly augment IP protection in China.
Really? How so?
Well, as long as the version is prepared by trustworthy legal counsel with adequate Chinese skills, it can be relied on to accurately reflect the SME's wishes. The greatest value of writing contracts in Chinese is that doing so creates tighter obligations on a Chinese manufacturer. With the Chinese language contract, the manufacturer cannot argue that wording was unclear or deceptive.
Right, because if the contract is written in English, the Chinese manufacturer can claim that he or she did not properly understand the contract.
Yes, exactly. Furthermore, with a Chinese language contract, Chinese courts will not have a chance to use their own translators who might misrepresent the contract.
I see. Now it's clear for me to understand why it is advantageous for European SMEs to use Chinese language contract.
Great. If you would like to know more about intellectual property protection in the OEM industry or the use of contracts, we highly recommend you to visit our website www.china-iprhelpdesk.eu.
You can also find our infographics, webinar recordings, or video podcasts on a wide variety of IP-related subjects.
With this being said, we would like to conclude today's podcast.
Thanks a lot for joining us today, and do make sure to follow the China IPR SME Help Desk on Facebook, LinkedIn, and Twitter to keep up to date with our most recent IP material.
And don't forget to subscribe to our Help Desk TV channel on YouTube or follow us on WeChat.
For questions, please reach out to us directly via question@china-iprhelpdesk.eu.
We hope you enjoy this podcast and hope you'll join us next time again.